right, then let's go on ahead. It's going to be 25,604. That is Scott Stovall versus CSC Barton Ridge Realty.
This is
Good afternoon,
Brecken's
on behalf of
fault.
Scott Stovall. Anyone here for Scott
Yes,
Stovall?
I'm here.
Oh,
Sorry.
good afternoon. Thank you. And do I have someone on behalf of CSC Barton Ridge?
Yes, present.
Who is that?
Nick Eaton with CSC Barton.
Good afternoon, Mr. Eaton. And are you owner, agent, manager, counsel?
Yeah, I'm with the ownership group.
Okay.
So representative of the owner.
All right, fantastic. All right. Good afternoon to you both. Mr. Stovall, Mr. Eden, why don't I go ahead and swear you both in? If you'll please raise your right hands for me.
Your Honor, can I say I affirm to tell the truth or something instead of swearing per se?
Yeah, sure. You understand that if you lie to me, you're in contempt and I'm going to find you responsible for that, right? You understand you have to say the truth when you're in court with me. Do you promise to tell me the truth?
Yes, under penalty of perjury.
All right, Mr. Eden, you understand if you don't tell me the truth, that's perjury and I'm going to get you in trouble?
Yes,
Well,
ma'am.
you'll have gotten yourself in trouble. All right, go ahead.
Oh, he doesn't want to swear. That's cute.
Thank you, Mr. Eden. Both
Grow
parties are
up.
sworn. All right. Okay, Mr. Stovall, why are you suing?
Okay, well, so there's a few different issues. I'll kind of try to keep them as simple as possible.
Start with this. Are you suing for money?
Yes.
How much money are you suing for?
I'm suing for, I listed 20, but it's 19,828 and 74 cents.
19,828. And what is that from?
So, let's see, there's multiple violations. So the first violation is retaliation. And for that, there's 1,070 plus 500.
Okay, so lease violations. What else?
Plus, yeah, so total for that is 1981 without time damages, because that kind of splits between all the different issues.
Mr. Stovall, how are you calculating your damages?
For my time, I kept track of my hours, and I used.
Are you an attorney?
What's that?
Are you a licensed attorney?
No.
Typically, Texas, you don't get anything for your time in bringing a case to court. You get your actual damages. Have you been harmed financially by the defendant?
Yeah, I mean, I had to spend a lot of time on this issue.
I don't doubt that, right? The court isn't able to compensate you for the amount of time it took you to bring the case. What you can sue for are actual damages. So what's the reason you were suing the defendant?
Well, so for retaliation, and then they kept on telling me that they would send me a lease to offer. I kept requesting a lease offer. They kept saying they would send one. They wouldn't send one, so I'd get charged month-to-month fees plus a premium rent, which is higher than.
So you wanted to renew, and they said no. They kept you at a month-to-month, and you didn't move out.
They would say that we're sending it to you, or they would say, hey, we're going to take care of all those past ones, and it kept going on like that. I have a whole email thread of it. Eventually, it got to be where he said, hey, how about we sign a new lease first, and then we'll talk about the fees. And I didn't feel comfortable with that, and I still requested a lease to review, and I've never got one from him.
Why are you unnecessarily wasting the judicial time of this court?
But and I'm a little bit nervous here, so excuse me if I lose track of my thoughts a little bit. But yeah, he basically they never gave me one. They kept telling me that they were gonna address the issue and whatnot. Finally, when he did say, let's do it, but let's do it after we sign a lease, and I didn't want to do that. I wanted to move out too because of a number of issues. Then I found out they were actually selling the place. That's when I filed the suit so that I could sue them before they're selling. I guess it didn't go through, but I didn't want to sue the next person for something that they did. And
Mr. Stovall, I'm reading your petition because I'm not following what you're suing for. So I'm going to read what you wrote, and you tell me where the claim of action is. Okay.
Yeah, if you can't say it in like 3 or 4 words, it's not going to work.
Defendant retaliated. I requested repairs and objected to a rent increase. They issued me a fraudulent lease violation. That's harmed my rental record. Defendant raised my rent without due notice as required by the lease, and then issued a retaliatory notice to vacate, creating financial and housing instability. I don't know about that. Defendant also charged month-to-month fees after falsely promising a lease renewal. So month-to-month fees after lease renewal. That seems like something that might be actionable. Month-to-month fees after promising renewal. All right.
And
I'm going to finish reading your petition, sir, but that's the first one I understand that makes actionable sense. Okay. Promised me a lease at a different rate, but they kept charging me month-to-month fees. We'll see. Imposing improper insurance fees despite proof of coverage. Okay, so maybe that's a lease fee, insurance fees. If you provided them proof of renter's insurance and they were charging you for it. All right.
that number
insurance
was just
fee.
210.
And then conditioned refunds on signing a lease.
That was just kind of describing it. That doesn't necessarily.
Okay, because I mean, that's, yeah. Plaintiff seeks damages under the property code and the Texas Business Code, removal of fraudulent lease violation. I don't know what
They-
record the lease violation would be on, sir, and I wouldn't have that's injunctive relief. I can't do that.
They've already done that. Well,
Okay.
they explained it. They kind of explained it to me like this, because I've been asking for more than a year to please tell me what this lease violation notice was for, and please get it off because I know it was false. Like it came to me after I made I complained to the manager, and I put in
All right.
two maintenance or 3 maintenance requests later that day, including one that was a rat that was in my house that just got
Mr.
into my
Stovall,
house.
did they remove the fraudulent violation before or after you filed the lawsuit?
It was, well, they never removed it.
I thought you
but
said
but they explained that it wouldn't that they don't report it to other
I don't know about y'all, but I'm ready to evict him. Let's have a show of hands. I'm ready to evict him now. He may be getting railroaded. I don't care. He's got to go.
to other apartment complexes, and that was my big fear. And I kept asking them over and over again, can you tell me, because this is going to affect my ability to move, and like I'm afraid to apply to a place because I don't want to get on a blacklist. They never explained it right until the end, right until they saw there was a court date. They finally said, hey, you don't have to worry about that. That's nothing. And so something that could have taken them 2 minutes. Same thing with fixing the month-to-month fees. These things that could
okay,
have
let's
taken
talk
a long
about
time.
how much did you incur in month-to-month fees, Mr. Stovall?
Well, I'm including $250 plus the premium $100 for extra for the premium rent.
Let's do it a different way. Mr. Stovall, you moved into this apartment complex and you originally signed a lease. Is that correct?
Yes,
And when you first moved in, how much was your rent?
$795. And
$795.
yeah, they didn't own
And-
it at that point. They bought it a couple
That's
years
totally
later.
fine, Mr. Stovall. The lease is run with the land. So you had a lease for $795. When did that lease, by its original term, end?
Oh, that was like 2017 and 2018 or something.
It's important that you know.
I mean, I can look it up.
Take a look at your
Oh.
lease. The very first lease you signed for $795. When did it start and when did it end?
Did you get my exhibits, by the way? By
I'm
email?
sure I did, but
Cool.
it's just
I'll find it.
right, because we had one plaintiff who sent us 800 exhibits and it actually shut down our inbox. We had to contact that person.
Okay, hopefully
The
that's
best of luck, y'all. I appreciate it, but like you emailing me 50 PDFs I have 3,000 lawsuits and they all emailed something. You just need to look and tell me when your lease began and ended.
Okay,
Mr.
Sorry.
Eaton, do you know when the original lease was? Because you can help us get there a whole lot faster, right? I just want to know the original term, when it ended, so that we know like when we finally went month to month.
There were
Oh.
several lease renewals in the time from the original that you mentioned to the point where it got to the month to month.
Per your records, Mr. Eaton, when did it go month to month?
Let's take a look at that last lease we have signed.
And Mr. Stovall, same question, because that's what I'm trying to get to, right? Like you had a lease and it got renewed and there came a point when you did not renew and you went month to month. When did that begin?
That began on when it went month to month was August. August was the last month. August of 2023 was the last month that I had a lease.
August 31st, 2023 is the date that I have in the lease.
So September 1st of 2023, Mr. Stovall was month to month.
Yes.
He didn't move out at the end of August, and if he stuck around, it went month to month. And were we all agreeing on that?
Yes.
Okay, so September 1st of 2023. And in the original lease, Mr. Stovall, did it already say if not renewed at month to month, this rent increases?
I'd have to look, but there is I understand like the month to month fees are a legitimate thing, but I'm saying it's deceptive trade practices
Yeah,
too.
I get there,
Sorry
and
about that.
I'm leading you to where you're trying to go, Mr. Stovall. I get it. What I'm trying to figure out is how long this went on, right? It gives me a
Okay.
sense of what happened with y'all. So in September of 2023, you didn't sign a renewal. They didn't demand it. You went month to month. Did
yes,
the rent increase when it went month to month?
It had to, so they raised it in September. I had to involve a lawyer to get them to stop doing that.
Of 2023?
Yeah, because they have to give 30 days notice per the lease to make any changes.
That's
to
what
it.
I just,
I'm sorry. Sorry.
Mr.
This-
Stovall, you signed a lease.
Yes.
Are you looking at your lease?
I'm pulling it up here.
Pull your lease up and let's look at it together. Mr. Eaton, are you looking at his lease?
Yes, ma'am.
When it went month to month in September 1st, did the rent increase from $795?
It was, so the 795 was no longer on that lease. The rent on this lease we're referring to is 1070.
So
Was
in
the-
the renewals, the rent had increased per the standard renewal, so that at that point, when it went month to month, it was actually 1023?
It was already 1070 in the active lease that expired on 8/31/23. The
Okay.
effective lease
Okay.
was yeah.
Mr. Stovall, is that correct? When your last full lease term came to an end, was your rent at that point $1,070 a month?
Yes. Can I say one note on that? So and there's some documents to back this up, but when I originally signed that lease, it was in February, I think. No, yeah, it was right at the end of January. They did actually raise my rent. I didn't know the law then that they had to give me 30 days. I had been trying for like a while to get the lease. Emails were bouncing back. One person didn't work there anymore that emails were going to. I couldn't like do it online. It wouldn't let me. Finally, and this company would call a million times and it would, like, I think during this time it would just ring and the messages would always be full. So it was impossible to get in touch. I finally got in touch with someone on the 30th and we worked it out and to get it signed in time and give me time to review it and stuff. The one thing that they did say though was that I would have an opportunity to link, because of the shortened time, that I'd have the opportunity to lengthen the lease and change the terms to something lower, like 1030. But when it came to it, and I tried to follow up on that, they
didn't do it. So they got you to sign something and then, all right, so you
Yeah.
signed a lease, you renewed at 1070, and then that lease came to an end and it went month to month.
Yeah, now that'd be before the statute of limitations, but that would include from March 23 on.
In September of 2023, your original lease, after all the renewals, came to an end and you went month to month, correct?
Correct.
And when you went month to month in September, were you then did you pay 1070 going forward?
I paid 1070 for one more month, and then they raised it to like 1225, I think, the next.
Okay, so then it went to what portion of so from September of 2023 until now, you've never signed a proper renewal?
Correct.
Okay, it was month to month. And are you still currently living there?
I moved out. I had to move out because they would not fix the AC, and I tried for 3 weeks.
When did you move out?
It was July 6th to 9th or something.
Of this year?
You funny.
Yeah.
Okay, so you were a month to
Sorry.
month tenant from September of 23 through June of 25.
Yes.
Okay. And what portion of that are
I-
you suing for fees?
I will say though that for it was 3 of those months. Oh wait, excuse me. Because one of the managers did stop charging it, and she refunded some of it. So that took off a certain amount. I'm sorry. And I'm not even necessarily asking for everything, but so from October and November, I didn't pay any.
Of 2023?
Yeah, there was basically like $750 worth that was like refunded to me. And then she didn't make me pay for October and November. But then
Mr. Stovall,
she quit or got fired because they have a lot of turnover. And then
Mr. Stovall,
yes,
what didn't you pay in October and November?
just the month to month. So 250.
That's what I'm trying to get to.
Okay, so
When you went month to month, your rent was 1070, but you had to pay an extra 250.
yes, plus they raised the rent to 1225, which is like
But
premium.
so the 250 is a month to month fee, and is that in the lease?
I think so. Yeah, I believe so.
If it's not, they shouldn't have been charging it, right?
Right,
Mr. Eaton, I see you doing that. Is it in the lease?
I was just going to refer to the clause from the lease that says this lease will automatically renew month to month unless either party gives written notice of termination or intent to move out as required by paragraph 25 on page 1.
Yeah, no, I know that, y'all. I understand how month to month works. You get stuck in it the minute y'all start a lease, whether you have it written or not. It goes month to month. My question is, he says he got charged month to month fees. Where does this month to month fee exist? Is it in the lease? That's what I'm asking. So what's the month to month fee? He says y'all charge him 250, sometimes not. I'm not really clear.
Yes, ma'am. That's our typical fee. I'm happy to take a look through the lease now and see if it's in there.
I'm looking to, but I do think it's in there.
Yeah. There are 400 pages of exhibits, y'all. I really only need to know that one piece of paper on the lease, the original document that said when it goes month to month, is there a fee?
That is definitely there.
Otherwise, I don't know why we're here. If you said you're suing for for month to month fees, what's that fee? It can't be the rent. You lived there.
Well, this 250, I've not seen it.
Oh, look at our glorious nation after 20 years of participation trophies and safe spaces. Nobody can answer an effing question. Not a basic freaking question. Everybody is shocked that the judge is asking them about the lease that they went to court on. I don't even know what to do.
Here right off the bat, and I can't search.
Because Mr. Stovall, ultimately what I would want you to say to me is, Judge, I, for 12 months, asked them to give me a renewal, and they kept promising me, here's all the emails where they said, we'll send you with the renewal, and then they never sent it. And as a result, I was having to pay an extra amount of money. But you got to be able to tell me what the extra amount of money is over and above what your lease would have been of 1070.
Okay, I can
That's for you to prove damages. You have to prove to me that you had an offer to renew at a different rate, and they refused to give it to you, and as a result, you suffered harm by paying more money.
And spit it out now, because if you don't, the next thing out of her mouth is going to be, plaintiff has failed to meet his burden. Case over. Bye-bye.
Can you show me that in your receipts?
Yes. So in the files I sent.
Oh, let me look up the only effing relevant thing that I could possibly say to the judge that I didn't have ready.
Month. Issue emails and then issue 3 month to month lease request screenshots. So the screenshots are just what I took from the web
We know what screenshots are, Jackwagon. Answer the question.
portal that would say, like, it would give you an opportunity to request a lease.
I'm gonna lose my mind.
This lease is being processed, kind of thing. That I was doing that at first. That wasn't working. Then I eventually talked to, if you look in the emails file, and I did it in reverse chronological order. So just to match the email thread. So newest is on top, oldest is on bottom.
Yeah, that's nice for you.
And I tried to keep threads together, but
I did provide the lease renewals in the documents that I provided. I provided a copy of those.
So in there it does include some of the ones I did offer. And then I have an email dated 3/1.
Yeah, I'm past this. If I'm the judge right now, like, you got about another 2 minutes. After that, we're dismissing this case for lack of prosecution. And I'm calling the next moron on my list. And I hope that they saw it so that they spit out what they need to, or I'll do it to them too.
Actually, February 29th, with the head and the top of that thread is 3-1, where I explained I was having difficulty accessing things. And then if you go up to my emails to Jay Gonzalez, I said,
No, Mr.
Jay-
Stovall,
I'm sorry.
Mr. Stovall, have you found the document that tells me how much more you had to pay month to month than you would have been paying at your standard renewal rate?
Only that there's nothing that I can scientifically say other than just other people's rents that were in similar situation. And similar,
Mr. Stovall, unfortunately, that's too specious for me to be able to make an award then.
Can I? Okay, for the 250, since I intended to show that they had knowledge of this, that this was happening, that they weren't doing it. Would
Can
that
you
be
show
triple
me that you were
damages?
paying $250 more every month solely as a month-to-month fee?
Judge, I want to offer an exhibit that might sort of tend to show that some hearsay evidence involving people not here that's irrelevant might be more probably true than not, but probably isn't. Oh, okay. Let's get right on that.
Yes.
Where?
In
That's what I was asking. What document?
Oh, in payment receipts, and I'm sorry, I do have a ledger I was about to send you to. I'm sorry. I understand. I just sent a ledger.
I don't want your ledger, Mr. Stovall.
Okay.
I want you to show me where in your lease it says that if you go month to month, they're going to charge you an.
I mean, it's a good thing, but literally, society's so advanced. I know you guys don't think it is, but it is. It's so advanced that people like this can exist. And this is, it's idiocracy. It really is. Because 100 years ago, Darwin would have just taken care of this guy. He couldn't have lived to this age. A bear would have ate him. And that's that.
Extra $250 a month.
Nick, can you help me out here? I know it's in there. It's kind of hard to read you can't search these PDFs for some reason of the TAS. I do know from payment receipts that I was paying $250. I'm not seeing it right now. I think I've always assumed it was just in the lease somewhere.
He doesn't have to, Mr. Stovall. Okay.
Well,
I'm gonna, Mr. Stovall, I'm gonna give you some information and I want you to hear it because you have the right to appeal the decision. But so far, you've not established a cause of action against the landlord sufficient for a claim.
Even okay.
Let me hear what I'm saying, okay? Because I understand what you're alleging. What I'm saying is that your facts and your law doesn't match up, right? If what you want to say is that I would have been able to save money if they had given me a renewal, you must show me a couple of things. One, you must show me that the difference between what you would have paid and what you were paying is only due to the month-to-month fee. And not just because rent got more expensive every month.
Well, a receipt would show that, right?
No, I don't know. Typically, it needs to be in the lease.
Well, I mean, like the actual payments themselves show $250 for a month fee.
Let me finish that. You would need to tell me a couple of things. You need to show me that you had a good faith offer to renew. The landlord gave you an offer and they refused to let you accept it. And because they would not let you accept an offer to renew at a lesser rate, you got stuck paying the higher month-to-month fee, which needs a few things. I need proof that the landlord offered a renewal to you and that you did not reject it or not accept it. So a valid offer to renew, that has to be shown.
But if they tell me,
second, Mr. Stovall, I'm trying to lead you to understand what's deficient in your case. So if you want to appeal, you can fix this and cure it. But this is why you're not getting anywhere, okay? You have to show historic evidence that the landlord refused your renewal, that they offered, and then somehow you weren't able to accept it through no fault of your own, right? They said you can only accept through the portal, but the portal never worked. I don't know. I can't tell you what your evidence must look like, but this would be a necessary element, that they refuse to give you the renewal that you were otherwise somehow entitled to. That's a tough one already, Mr. Stovall. No landlord in Texas must renew. Every single landlord, regardless of how good the tenant can be, can say, I no longer wish to have you as a tenant.
Can I
Let
ask
me
you a question?
finish. Mr. Stovall, you must show that they prevented you from renewing and that prevention harmed you because you had to pay a greater rate only due to it being month to month. If the reason the rent went up every month is that rent's going up in Austin, that would be a reason. So those two things, you would have to show me historical evidence that they refused to your renewal through no fault of your own, that they said you could and then you didn't, and that even ongoing every month, you were only paying more rent because it was a month-to-month thing and you couldn't lock it in.
Go Sylvia Holmes. Judge, I think it's the first time I've seen you. Maybe not. I don't know. But she's saying everything I'm thinking, except I get to say it all nasty. But she's sitting on the bench and she has to, maintain some dignity. But we're in the same place. We're in exactly the same place on this case.
I believe I have that information right now.
Can you immediately direct me to it?
Yes.
Immediately direct me to it.
So on the improper month-to-month issue dash emails, issue 3 improper month-to-month issue dash emails.
Mr. Stovall, I received 2 documents from you, 2 batches. One is 243 pages, the other is 163. Where in those documents would I find what you're trying to show me?
I think I sent them. Oh, maybe does it show more show more attachments?
I just have 2 giant PDFs from the plaintiff. They're both batches.
Do they combine them maybe in the email?
Yes, I combined them all because they're individual emails and it was easier to attach, especially
Okay.
since he sent them like 30 minutes before the hearing.
Yes,
Yeah.
I very much apologize for that. I know that's not good.
Should have been done 3 days ago, y'all. That's very rude and disrespectful to the court. 400 pages, 30 minutes before a hearing with 6 cases. Do you understand, Mr. Stovall, why that is not okay?
I know that was
So
fine.
pull it up on your screen and we'll let you screen share. I want you to get to the information so we can award you a judgment. But right now you have not established any cause of action whatsoever.
Okay, I just sent her.
And it's been 30 minutes.
And I accepted that request.
Bye-bye.
All right, what document am I looking at now, Mr. Stovall?
Okay, so this is an email I sent on June 28th, 2024 after talking with Jay Gonzalez on site. Just wanted to let you know I tried to request the lease renewal last night for review. I'm just following up by email because he asked me to do that. He said, okay, thank you. I'll let Perla know. August 1st, Jay, I never received a renewal offer. This has now been made.
Got it. Mr. Stovall, show me something where they say the renewal is coming. Because if you just kept asking them to marry you and they just kept stalling, that's not illegal. That's
not
nice. I grant you, that's, them dragging their feet, but it's not improper or illegal. You need to show me something where they said the renewal is ready, go sign it.
Well, I mean, like,
I understand what you're saying, Mr. You asking them to renew does not obligate them to give you one. It doesn't.
Right. But the fact that they would say, yes, we're going to do it. And then, so I don't know.
Show me that. That's what I'm asking. Show me one where they said, yes, here's your renewal.
Well, that's
what I saw. I did not see that in those
They're saying,
communications. What I
we're
saw was
continuing-
we'll let them know.
They wouldn't necessarily say, here's a renewal, but they'd say, we're sending you a renewal. And I'm
Show me
that. That was just that.
I don't see that. I see, I'll let them know. That's not the same thing. Okay,
Okay.
thank you. I'll let Perla know.
Well, there, I could show Sydney tells me that that it's all gonna be addressed.
Imagine some woman trying to break up with this guy. I mean, he'd never get it. First of all, well, I don't know that he likes women, but let's just assume for my hypothetical he does. What would you have to do? What would you have to do to get through his thick skull?
I spent so much time trying to not have this in front of you.
Mr. Stovall, I'm afraid that it's plaintiff take nothing today. You absolutely can appeal. You have 21 days to do that. I would say, Mr. Stovall, to be most effective in the 21 days, reach out to legal aid and help them, have them review what you're talking about, okay?
They
A specific thing that we need is them agreeing to renew. I have not yet seen that here.
I've got it here coming up.
Okay.
Uh,
Mr. Stovall, as the plaintiff, if you wish to appeal, it's a $500 appeal bond. If you can't afford that, you can apply for a waiver and you can appeal essentially for free. Okay?
Yeah, I'm so sorry for the response. I will follow up again with my regional to get some of the answers you see. I will also
See, none of those say we're renewing.
they say we're sending you.
We'll talk to you. They
Yeah.
gave you a runaround, but that's not illegal or
Yeah.
improper. That's just maybe a reason to move. Mr. Sandoval, Mr. Stovall, we can't continue here.
renewal
Okay?
request has
Mr.
been
Stovall,
I'm sure Brecken did that for me, so to protect information.
Please
Mr.
review. Your renewal request has been accepted. Please review.
that's an automatic message. That's not someone human saying, here comes your renewal.
So
That's you
why I
requesting it.
started that's why I started talking to them by
I know.
phone and email.
Okay.
But
Mr. Stovall, unfortunately today it is a plaintiff take nothing. You
Okay,
have
but-
21 days. Tomorrow is day 1. It's
But
21 calendar
in the insurance money,
insurance money for.
where they were charging me insurance when I kept trying to get it removed, or they're
You haven't proved anything. You lose. You are awarded 0 points. We are all dumber for having listened to you. All of that. Good day, sir.
first retaliation. I don't. Man, it's really hard to communicate this stuff. Like this has been like
Mr.
such a
Stovall,
burden.
please contact legal aid or the
I
tenants
did,
rights group to help.
It's really hard to communicate and stuff. I don't know. I'm not having any problem.
Help
They
you.
they only helped me for a little bit and then they stopped and they
Okay.
no,
Unfortunately,
they
I
really did,
cannot
like-
assist you. I cannot advise you. I can say that what I'm hearing today is not sufficient to establish cause of action or damages.
I know I haven't presented it well. I
You can
don't
do it
believe-
again if you appeal. If you don't do anything, this becomes over and done after 21 days. Okay, sir?
Okay, so 21 days. I have to pay 500.
Tomorrow's day 1 and it's 21 calendar days.
Okay. Is there anything weird? Is it just I know like in like criminal appeals there has to be like something wrong with the process. Is this
Nope.
just like
Nope, you don't have to have anything. Nope, that's a great question, Mr. Stovall. In justice court for civil matters, you can win an appeal an appeal without any reason at all, just because you didn't like my opinion or you wanted more money. It is not required that you have a cause to appeal from justice court. And the Latin term for that is it's appeal de novo, meaning it's completely brand new. The next judge wouldn't ask you what happened. They wouldn't say what Judge Holmes say. They wouldn't ask what Mr. Eden. They would. It's a brand new thing with a brand new judge. Okay.
and
Scott, it's a whole new world, buddy. It's de novo. So you can go make a fool of yourself all over again. I mean, you could theoretically win, but you're not gonna.
do you know who the judge is?
It would be either Judge Wong or Judge Shepard. It's going to be appealed to the county court at laws, and you get assigned to either one or two. If you contact our court this afternoon or tomorrow, we can give you the information about appealing, and then you have 21 calendar days. All right, sir.
All right.
All right. Good luck, Mr. Eden. Thank you. All parties are excused.
Thank you, Your Honor.
Then let's move to the next one. That's going to be CV 25-000591. This is Amanda Bridge versus Bernadette Gasper. Do I have someone first for our plaintiff, Amanda Bridge?
Yes, that is me.
Good afternoon, Ms. Bridge. And do I have someone on behalf of the defendant, Bernadette Gasper?
Yes, Your Honor, that is me, Bernadette Gasper.
Good afternoon to you as well. All right, Ms. Gasper, Ms. Bridge, thank you both for being here. I'm going to ask if I can go ahead and just have both of you.
Oh no. Just based on these openings, I feel it coming on.
You raise your right hands. I'm going to swear you both in. All right. Do you understand that by appearing in court and offering me testimony, you are swearing to tell the truth, the whole truth, and nothing but the truth under a penalty of perjury? Do you so swear?
I do.
I see.
Fantastic. All right, thank you. All right. And Ms. Bridge, you have instituted the lawsuit. Ms. Gasper, I don't think, we don't have a counterclaim though, right? This is just a single.
There was not a counterclaim submitted, no.
Just making sure. All right then. Real quick, I'll give both of you a bit of overview. So Ms. Bridge, as the plaintiff, you'll always get to start and end the situation, right? So first you tell me why you've sued Ms. Gasper. If you're suing for money, tell me exactly how much money it is, right? That way I'm because what I'm writing down is what is it you're trying to get and how do we get there? Ms. Gasper, as the defendant, you are literally allowed to say absolutely nothing for the entirety of Ms. Bridges' case. You're allowed to be completely silent until she says, Judge, that's it. And then you're allowed to say any and all things back. Certainly, I'll give you each a chance to ask questions of the other. Given that you're just both solo, what's called developing the case, I may occasionally, and I hate to say, I might interrupt and be like, hey, let me ask you this, because I'm looking for very specific information. Okay? All right. All right, then. Ms. Bridge, why don't you tell me what this lawsuit's about?
Great. Good afternoon. I'm the plaintiff, Amanda Bridge, and I am seeking repayment for $2,919.17 from the defendant for costs she agreed to reimburse from a shared vacation from June to July in 2023. I have lots of evidence. I've submitted like a bunch of exhibits for you to reference. If that's not available to you, I'm happy to
It looks like she's trying out for Chi Omega.
on my screen. But in addition to this $2,919.17, I'm also seeking documented damages and statutory interests of $1,791.59,
Plural interests. That's good to know.
resulting from her failure to pay, as evidenced by exhibits B, C, and D. So really, I'm here to collect what is owed, which is $2,919.17, but total, including at your discretion damages, it would be $4,710.76. So here is my statement.
That's perfect. That's a great opening statement. Just real quick, Ms. Gasper, do you want to make a statement now or do you want to wait till the complete end of Ms. Bridges' case?
Sorry, that wasn't the end of my statement. That was just. No,
I apologize, Ms. Bridge. I thought that was the conclusion of your opening statement. Go ahead.
Cool. Okay,
there's
so
more.
from
There's more.
June 18th to July 2nd, 2023, the defendant and I traveled together to Ireland and Greece. I initially planned for her plane ticket up front on May 1st, as seen in Exhibit A5, and she agreed verbally that she would pay me back for it.
Okay, Ms. Bridge, you're actually getting into testimony, so that is not the same.
Okay. I don't understand.
I just want to know this. Ms. Gasper, you have the right to right now. She's suing you for a little over $4,000.
Yeah, we know.
You could right now say, Judge, it's correct, but I already paid her back. Or you could say nothing, or you could make a statement. It's just your choice, Ms. Gasper. Would you like to make a statement now? And it's a short statement, or do you want to wait till the completely end?
Yeah, I would like to make a short statement if that's all right.
Yeah, absolutely.
So I am here today being sued by the plaintiff for the amount that she had mentioned, which includes a base claim of $2,919.17, which the plaintiff asserts that I owe her, in the additional amounts that she labels as damages and additional costs. To date, I have not been provided with an expense report that is including receipts to verify the accuracy of any of those amounts. Without full documentation, I can't verify any amounts that may or may not be owed.
Ms. Gasper, if I'm reading between the lines here, your defense is not that you don't owe her the money, but that she hasn't showed you owe her that much.
Not necessarily.
Question, Ms. Gasper, do you owe her money from the trip y'all took to Ireland and Greece? Yes or no?
I do owe her money.
Great. So we're halfway where we need to go. How much do you agree you owe her?
I would believe it's somewhere in the base claim amount of the $2,900. However, she does additionally owe me money from that trip that she has not paid at all.
And how much is that?
That I show is $752.17, which has been made in no partial or full payments.
So if I'm giving you full credit and taking it as true, you owe her $2,200.
Somewhere in that range, yes, Your Honor.
There's no dispute about that, right?
Mm-hmm.
Okay, great. Look at that. We're already halfway there, y'all. All right. Ms.
Word.
Bridge, what are the $1,791 in damages?
The damages are, let me pull this up. So, on top of her debt, I've experienced significant stress that required professional support.
You don't get any of that.
Don't need that.
That may be true, but legally what you get for a breach of contract is actual damages. And then if you had a written agreement for interest, you
I'm really liking this, Judge. You don't. That's exactly what I was thinking. She's like, just knock this crap off now. It's not happening. I get it. There's annoyance associated with this that you're not going to be compensated for, but you're not. It's not the law. Stop.
have a written agreement,
No.
then what else is the 1791 from?
It is from filing fees
You
and
get that?
costs.
Because that's what that actual cost you had to spend to come to court. Okay, what else?
Legal costs.
How much did you incur for legal expenses?
$186, as well as my
Court costs are recoverable. So you filed it and you had to pay, I don't know, $400 or whatever to file the complaint. Fine. You can recover that. Maybe if you placed summons for service and that kind of stuff, you can recover that.
demand letter, which cost me $17.57. This demand letter included the receipts that the defendant has claimed she did not receive.
Ooh, a $17 demand letter.
186.
$186. These are an exhibit.
That seems like way too much and not enough all at the same time. I mean, $17 is way too much for like a piece of paper, but not nearly enough to have an attorney do it right.
Exhibits C1 through 4, and they are working with lawyers.
Okay, so 186 for the lawyer, 18 for your mail cost, your cost of court, and then 2,200.
No, it is $2,919.17.
I know. She's admitted she owes you 2,200. Right, like she just said, I know I owe her money. I think she owes me $750. So without fail, Ms. Gasper's acknowledged that she owes you $2,200.
This is not true. If you, in Exhibit A0, you can see a complete breakdown of our splitwise costs.
Ms.
with the
Bridge,
total-
Ms. Bridge, Ms.
Yes.
Bridge. Hey, listen to me quickly.
Okay.
At the time y'all entered into the trip,
Mhm.
did you put in writing that you were lending her money and she was going to pay you back?
We agreed to it verbally.
In writing.
In splitwise, yes, that is in writing.
Where is that in your exhibits? Let me see the agreement to loan her money and she repay you. Because if it's in writing, you got a hell of a case. If it's not, you're getting $2,200.
Yes.
Kim Blandino in
And
the
that's the
house.
reason. And Ms. Bridge, Ms. Gasper, there is a very important doctrine called the statute of frauds. If you can't pay someone back within a year, you have to put it in writing. So if you're telling me that she agreed to pay you back, I need to see it verbatim. Otherwise, I'm going to give you the 2,200, which she just admitted she owes you. And we are all good.
Yes. So Exhibit E6 is her saying that she agreed to it.
And when
then
was that? Let's
that
see.
was July 18th, 2026.
Nope. We can't be
Or
2026.
sorry, 2023. My
Okay,
bad.
let's take a look. Let's take a look. So I'm looking at what is exhibits E1 through E10. I'm going to share my screen. All right.
And then
Here's what
also
she said it was.
E14 also.
All right, so let's see. So here we are. Reminded debit to report expenses.
We are in E6.
Okay. All right, Ms. Gasper, when I'm looking, I'm sorry, Ms. Bridge, when I'm looking at this first one here, who is speaking in the black text on the left-hand side of the screenshot?
That is the defendant.
Okay, and who is speaking in the blue on the right-hand side?
That is me.
Ms. Gasper, is that correct? Can you see these? Are you the person speaking on the black on the left, and is the plaintiff the person in the blue on the right?
Oh no, she's got she's got an Android. This isn't good.
It does appear so, Your Honor.
All right, and I can see that these are screenshots that are from July 16th through July through 2023. All right, when did y'all leave on your trip?
We were there from June 18th to July 2nd, 2023.
So these are messages after y'all were already out and
Yes.
about.
Yes. So what exhibit I
Let's see.
think what E6 is that we met in person. And then if you look at exhibit E7, which is next, you can see
Ms. Bridge, let me take a look at this one. You said this one says she promises to pay you back. So let me take a look here, because this one is July 18th at 9:51. Okay, so we actually are going left to right. I can read these as they appear. All right, just change it to 8. Perfect. Hey, friend, you want to meet somewhere for a drink or FaceTime? I can do a drink. Absolutely. What time? Let's go to Wanderlust. Okay. Headed to it. Sorry, headed out. Cool. Great. Made it home. None of this says she's paying you back on this page. So let's go to the next one.
So
This says she gave you money. That doesn't say she owes you anything.
yes, so what
How about
the
this one? August.
So this is substantiating my claim that we made a plan to discuss repayment, which was
Oh,
set
good
on July
Lord.
18th. E4, if you go back up to E4, it says she met with her financial advisor, which then we met in
Oh my
person.
God.
And
Oh my God. We are lost. We are lost as a nation. This is 2 in a row. 2 in a row.
That I gave Ms. Milligan, I'm assuming bacterial vaginosis.
she met with her financial advisor to establish a repayment plan for me of
You go to your financial advisor to discuss $2,000. Are you kidding me?
$500 upfront and $200 a month until the debt was settled, and I agreed, which is evidenced in these two things. And so the repayment plan basically would take 15.5 months from July 18th.
Ms. Bridge, I don't see that anywhere here. I'm looking at just this, right? Because this is the historical record. I know you're strapped for money. Can you give me some insight into Splitwise?
Yes, that is an
What has been causing you anxiety? I see nothing in here that says $500 per month going forward.
yes. If you okay. Sorry, I had a whole statement prepared that walks you through the evidence.
I just need a written record, a historic record where she says, I will pay you back a certain amount of money. She has admitted in court today to 2,200.
Okay,
You're
go to
saying the
A0.
remaining 700.
Okay, great.
But in order to do that, you have to show me that y'all agreed in writing with specific terms and conditions. This is just y'all talking.
Yeah, go to A0.
Okay, let's take a look. Is that exhibit A trip receipts?
Yes.
All right, is this exhibit A0?
Yes. So these are all the required.
Who created this document?
Splitwise, the app, and then I printed it.
Okay. And what is Splitwise?
Splitwise is an app that allows you to input costs and expenses, and then what it does is it automatically settles it. And so what the defendant is claiming is what I owe her less what she owes me less what I owe her. So the $2,300 is basically the 29,000 or 2,900.
We know.
Whatever. Subtracted from what I owe her. And so in exhibit
We arrived at that conclusion 10 minutes ago. Are you serious?
A, I've labeled 1, 2 through 20, each of my receipts, which the defendant has received in the demand letter. And this is our documented split of costs that we have been withhold.
So when I look at the bottom here, it says 2292.
Yes. So what it does is it automatically subtracts what I owe her from what she owes me.
Yeah.
This doesn't prove she owes you 2,900. This proves she owes you 22.
Yeah. So if you just look at my costs, which I've highlighted, those costs add up to $2,919.17. And then the ones that are not highlighted are things that I owe her, which I have not received receipts.
Ms. Bridge, Ms. Gasper, as I look at this, it is literally split. And each of you at the bottom of these columns, which are labeled Amanda and Bernadette, right? You'll have the same amount. She's admitted she owes you the 2,200. I'm looking for proof that she agreed to pay you more than that.
So it's like, so if you look at this, it says, for example, line 1. So it's
Drinking in public, $134. Y'all each agreed to split it, $67 each.
But then it'll add, like, for example, $10 TV, phone, internet, $10. And so from that, it'll say subtracted, like,
And again, Ms. Bridge, you've got a case you're winning right now. I'm going to give you $2,200. If you want the other 7, it is necessary for you to show me an agreement where she says, I will pay you back $2,900 by this date, or I will make payments of these amounts. What you've shown me is a very loose agreement that took place in advance and what she's just admitted to owing you, but I don't see the additional $700. I got you covered. $2,200, you're winning that plus your cost court. You're solid.
I'm saying that she can claim all of her costs, but right now I'm giving her $700 that she has not provided receipts for. I have provided receipts for all $2,919.17. And if it's the $2,200, it's giving her $700 off of what she owes me.
That's right. But Ms. Bridge, I wouldn't give you anything.
I now it just gets down to basically she admits it, but she doesn't want the receipts. Although it conforms to the crappy app that she's using. The math it is right on. Oh my God.
Oh, sweet Jesus. What?
If she hadn't admitted it today, because you don't have an agreement in writing for her to pay you back.
I have it in person. We agreed.
I know that, but what I'm saying, Miss Bridge, is that morally, friendship-wise, responsibly, she may have said that. Legally, for me to be able in court today to give you a judgment for that, you had to have put it in writing within the first 12 months. You can't change that after the fact.
Okay.
It's not that I don't believe you or that I wouldn't understand. Legally, I can't. She admitted in her opening statement that she owes you $2,200. We're good. You've won. I can't award you the extra money if you don't have a historical record that she promised to pay it back in 2023.
Okay.
Okay.
We don't need to do the additional 17,000 or 1,791.59.
I can't give you that anyway.
Fine. But if you, in Exhibit 0, if you total everything that the defendant owes me,
it's $2,292.
No, that's less what I owe her, which she has not provided receipts for.
Ms. Bridge, again, your receipts aren't proving your case. The reason I'm giving you an award today is because Ms. Gasper literally said in court, I owe her the money.
Mm-hmm.
If she had not said that, you would have received nothing from me today.
Okay.
Okay? You absolutely can look into appealing my decision for the remainder of the money, but please go and look into the law about contracts. Because the thing that I'm saying is that you would have received nothing but for Ms. Gasper admitting she owed you $2,200.
Okay.
Okay. Judgment for the plaintiff, $2,200 plus your cost of court.
Great.
Your Honor, I did want to ask really quickly. I realized reviewing my notes throughout this case that there are $200 that were not accounted for that the plaintiff did not mention that I have paid her since the lawsuit has been filed, that need to be tacked on to the $752.17 that I had mentioned in my opening statement.
That's false.
Y'all, judgment for the plaintiff, $2,200 plus cost. Y'all can both appeal that. All right. Did y'all have a nice time? I know I'm sincere. I understand it's not nice now, but traveling Europe is an amazing opportunity. Did you enjoy yourself?
I did, Your Honor.
Yeah. I want y'all to look back on your photos and not go, ugh, and have that be just a horrible situation. I know money is not a fun thing, right? But you got an opportunity to get out of the country? That's great. Very, very few young adults ever leave the state, let alone get to another place. So kudos on that, y'all. All right. All right. All parties are excused. Thank you very much.
Thank you.
All right. People against Craig, Alicia Marie Craig, 25W838685, A and B. Yeah, your name, ma'am?
Alicia.
You're charged with operating with the presence of drugs and drive while suspend. You have the right to a lawyer.
Yep.
I'll be happy to give you one. Would you like a lawyer?
Please.
Okay, so we'll set you up with a lawyer. You'll go talk to the lawyer. And then either way, you're coming back in front of me today, okay?
Okay.
You're welcome. Alicia Marie Craig, 25W838685, A and B. Is Alicia Craig here? Did you talk to your lawyer?
Yes.
Who's your lawyer?
I can I tell you that
Mr. Carmen.
Mr. Carmen.
Can you get him in if you would? Come on up to the podium, ma'am.
I was actually out there looking for him. I forgot to tell him something, but I guess I'm ready.
Mr. Carmen, your appearance, this is, let me call the case again. Alicia Marie Craig, 25W838-685A and B, your appearance.
Michael A. Carmen, P7324, on behalf of the defendant.
Ma'am, your name?
Alicia Craig.
All right, so today is the date scheduled for arraignment on an operating with the presence of drugs and drive while suspended, revoked, denied. For purposes of arraignment, how does she wish to proceed?
Your Honor, she'll stand here and wait the formal reading.
Okay, I'm entering a not guilty plea, ma'am. I'm gonna give you a $1,000 personal bond. She does not have any prior, oh yes, she does have a prior in 2020, right?
I believe that was out of state, yes.
Yes, okay.
I mean, it still counts. I just want you to know that,
No, it does.
okay? All right. $1,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no illegal drugs. You're not to purchase, possess, or consume any one of those. No contact with prosecution witnesses. Attend NA at least twice a week in person. We're going to give you a form. You have to go in person every time you go. You have to have the form signed every time you come to court. You have to bring the form with you. So again, no alcohol, marijuana, or illegal drugs. NA twice a week. No contact with prosecution witnesses. We're going to give you a new date. It's going to be what, October 1 again, Lisa?
9:30.
At 9:30, okay?
Your Honor, my client is prescribed marijuana for chronic pain and anxiety. She uses it 3 times a day. She's been prescribed since 2017. Can she use that one on bond?
Is that a medical marijuana card?
It is, but I believe hers is expired.
Well, I can't.
And how is that working out for her? Here we again we have the fantasy of marijuana is going to solve your problems. No, it's causing more problems than it's helping. I guarantee it.
The reason I did not renew it is because it became
Hang on.
legal.
I can't give you permission to use marijuana when you don't have a medical marijuana card. I can't do that. I mean, that's like me, the judge saying it's all right to do. No, I just can't. I'm sorry.
If she gets it renewed, it's valid, can't she?
Well, if she gets it renewed and you guys bring it up, I will certainly give her.
Just
Ma'am,
$1
hang on.
I don't think.
Hang on. I don't think we should talk about this much now. You've got it looks like marijuana was the culprit here, right? Ma'am, let me just talk to your lawyer. I don't want you to say anything. Well, I don't want you to say anything against your, right, against your interest here. It looks like marijuana was the primary culprit in this, right?
That's what's
So now
left.
you're asking me to say it's okay for her to use marijuana when she got charged with operating with the presence of drugs. I'm not doing it. Now, I don't overrule voters or the legislature, okay? She gets a valid medical marijuana card, you guys can renew your request, but this scares me because you can't go out and drive around with it in your system like that. So that's what I'm doing. NA twice a week, no alcohol, marijuana, or illegal drugs. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You're gonna have to fill out a petition for a court-appointed lawyer going forward here, okay, ma'am? Do you understand that?
No, but I'll figure it out.
Well, this, lawyers are appointed for arraignment. If the rest of the representation is based on indigency, so you have to disclose your income and fill out that form. I'll look at it. I'll be glad to appoint you one if you qualify, okay? Thank you.
I'm sorry, Your Honor, what was the next court date?
October 1 at, what'd you say, 9:30, Lisa?
Yes, 9:30.
Yeah. Okay. Thanks. Aaron Stephen Francia, 25W8392766A and B.
This, you didn't understand what told her. That's correct.
What didn't you understand?
Did you want 2 NA and 2
2AA or NA,
2 NA or 2 AA?
or a combination?
Okay, just 2 total weekly. And then, as far as the marijuana, I wasn't understanding because I'm.
Come on back up.
Come back up here, man.
Alicia Marie Craig, 25W386858B. Slow down. You gotta slow down.
Can I get?
No, just slow down. Tell me your name.
Alicia Craig.
Blake Harmon, B73824 on behalf of.
You can go to AA twice a week. You can go to NA twice a week. If it's more of a drug problem, you should probably go to NA. And you can go to any combination. I cannot permit you, I will not permit somebody who comes in here on a drug driving involving marijuana to use marijuana when they don't have a medical marijuana card.
That's not what I'm asking, Your Honor.
What are you asking?
I'm asking, I just would like to speak instead of being yelled at.
Am I yelling at
Not
you?
you, him, when he's got upset, he's supposed to be working for me, and I'm just trying to understand, even talk.
Yeah. Good job, attorney. She needs a talking to, seriously.
Ma'am.
But go ahead, give us some of your stony thoughts. This ought to be good.
I'm asking if I come back.
Ma'am, let's back it down. Let's back it down.
Yes. I'm asking when I come back on my court hearing, when I drop, there will still be marijuana in my system.
You don't need to worry about that. You're making admissions
That's-
against, hang on. You're making admissions against your interests, which is what I just told you you shouldn't do, and I think your lawyer did, because all I know is they think in the citation that there was marijuana. Now, it was marijuana's involved. So why in the world would you come up here and start telling me you're going to test positive for marijuana? Don't do it. You're not a lawyer. I know we get at least 7 people in here every day that think they can be lawyers. They can't be. I've seen maybe one do it slightly average in my 31 years on the bench and 41 years as a lawyer. So you just gotta relax. Nobody's asking you to test anything right now. I never said you're gonna test.
No. Because I'm scared because of yesterday.
What happened yesterday?
I spoke 3 times a day that we had said, and I don't want to get in trouble. When I come back to court, I'm scared to get in trouble. You guys,
Hold on. What happened yesterday? Do you know?
I spoke marijuana 3 times a day, and
Ma'am.
that's all. And I just wanted to.
What part of shut up do you not understand? We know, Stoney, you're an addict. You're an alcoholic and marijuana addict, and probably other things as well. We already know. Shut up. Your attorney told you. The judge told you. But it's probably best. And if you want to avoid getting in trouble, too late. You're in court because you're in trouble. Because you smoke marijuana and you don't listen to people.
And why are you coming up here and admitting this to me? You got a lawyer. Stop. Stop. Ma'am, just let everybody do their job here. Nobody's going to be unfair with you. Why would you come in here and tell me this on the record when you got a marijuana drug charge? A drug driving charge? You don't have any business telling me this. Don't tell me this stuff. I don't want to know about it. You tell your lawyer. And then he can tell me what he wants to say and what he knows is going to hurt you, not say, etc.
And Your Honor, that's why I didn't speak previously, that my client just used medical marijuana.
She can't use medical marijuana because she...
Today. It's been prescribed her since 2017 for back pain. And
That's great. She's going to have to get a medical marijuana card.
I understand. That's what I.
And then I'm still going to have some issues, but we'll see. I mean, I'm concerned about this. The more I hear, the more concerned I get. And you had one 4 or 5 years ago. You're going to have a revoked license, ma'am. If you get convicted of impaired or OWI, you're going to have a revoked license.
Yes, sir.
You're not going to be able to drive from here to that council table right there. You're not going to be able to do anything except have somebody in the driver's seat and you push the car. Stop telling me these things. Talk to your lawyer. I did not say one thing about testing. You put me in a position where I probably have to order testing now.
Let me just clarify. Sorry.
Your lawyer knows. He's been in here.
Sorry, and if I may, I just noticed on my schedule, I'm not here October 1st.
Well, whoever is going to be the lawyer here is going to handle the case.
Just want to clarify.
Okay?
Make sure that our lawyer gets his covered.
All right. Thank you.
Thank you, John.
Thank you.
Miss Bunch. Okay, the charge that took you there to the jail is called speeding 50 and a 30. Fine range is $1 to $200. Court costs are $134. Do you want to plead not guilty because you want to hire an attorney or have a trial?
Sam Whitman's fault.
No, I was gonna see about getting time served.
Well, I'm going to give you $300 jail credit. That means you still owe 70, so you're not quite time served.
$70.
Yep.
So if my husband comes and pays the 70 with the other part, because they were gonna bond me out last night, like for like 500 to just pay up the ticket in full, and the jail would reimburse. But then I got told I had a public intoxication charge.
The prosecutor didn't want to file that, so all you have left is the.
I was never in public. I was at home and I called to serve this ticket out on my own.
The prosecutor didn't file it.
So what do I need to do to go home today?
Going home today, no matter what you decide. If you plead not guilty, you'll sign a bond.
Well, I was speeding. I'm not gonna deny that I wasn't.
So
but
either plead guilty or no contest.
I just know that I had a ticket and I really, I don't know. I don't know.
So the choice is not guilty, bond out, come see me on the date and time of the bond, plead guilty or no contest, and come see me to talk about how to pay the remaining $70.
Can I, that's a PR bond, right? Paying
Yeah.
the $70 later. Can I do that?
Well, no, you're confusing things. If you just want to talk about paying it, you plead either
I
guilty.
can pay it right now or I'll come pay it tomorrow.
You can pay it tomorrow, right? You can pay it tomorrow if you can pay it.
Okay. I
So
can pay it.
to do that, you either plead guilty or you plead no contest.
No contest. Does that change anything?
No, it's the same.
Okay.
Fine and court costs total $370 with $300 jail credit. As you leave the jail, he's going to give you a map with directions to my courthouse. My order is for a jail release hearing for you to appear tomorrow, no later than 1:30 for a 2 o'clock jail release hearing. That's how you talk to me if you can't pay the 70. If you want to, you can, he'll give you a map. It has a payment website on it. You can go online and pay the 70. Then you don't have to come down here to talk about paying it if you've paid it. But if you haven't paid it, don't miss the hearing.
So I can go home from the jail tomorrow at 1 o'clock.
No, you're going home today.
Okay.
You're getting out today with an order to appear at my courthouse downtown Amarillo tomorrow
My kids.
or pay it. I'm sorry.
I said I just stink. I miss my kids and I just want to go home. This is.
I'm sure you do.
I got myself in for a speeding ticket and I've ended up here for 3 days.
You haven't been there 3 days.
If you didn't know, y'all stink. Okay, that's just my opinion.
I came in the night before last and I was here all day yesterday, today, and the night before.
You came in.
They didn't book me. They stripped me naked and threw me in a cell for like 12 hours. And then booked me the next day at like 12 o'clock right before I see the judge.
Okay. You're welcome to return to your pod. I'll see you tomorrow if you haven't paid the 70, okay?
So do I just call my husband or how do I go home?
The guys in the back will tell you what you need to do.
Okay.
All right. I had to get it out. I had to get it out since Kim was in the chat tonight. Big shout out to Brecken. She had that ready for me today, but then stuff kept coming up and I wanted to get it in. And I'm glad I did. So, you know, I had eating issues there for a bit. I don't know what the hell happened. I don't know why I couldn't figure out that the video wasn't up and I was sitting there eating my chicken nuggets in front of you. Whatever. I'm going to go claw my eyes out now. Thanks for coming out.